We're going to be talking for the next hour about workplace social media, and specifically some ways for organizations to manage risk that is really inherent with our employees being online and connected and sharing information in a 24/7 connected social world. We're going to be talking about both some risks to your all business brands from your employees being online and some of the legal risks that goes with employees being online as well. Before we start, I just want to give a quick warning. This presentation has been rated PG-13. Unfortunately, or fortunately for me, I guess, when employees go online and write things, post things, it can get salty. There are lots of real-life examples in the presentation, and you will hear some four-letter words. If that offends your sensibilities, well, you've been warned, so what can I do? I want to start with a story, and the story is about a woman by the name of Heather Armstrong. Does anybody know who Heather Armstrong is? Okay. Heather Armstrong writes a blog called Deuce.com. And the New York Times has called Heather the queen of the mommy bloggers. Deuce.com, she writes about her life as a mom. I think according to the Time, she had earned something like $1 million a month in ad revenue. She gets millions and millions of visitors to Deuce.com on a monthly basis. And she's been writing Deuce.com since 2001. And she writes now about what goes on in her life as a mom. She's recently divorced. She writes about her divorce, her dogs, her kids, dating, what have you. When she started Deuce.com back in 2001, she wasn't a mom. She wasn't divorced. She had no kids. She was a mid-20s woman living in Los Angeles, working at a internet web design startup company. And she wrote about what was going on in her life then, too. But back in 2001, what was going on in her life at the time wasn't her divorce and her kids and her dogs, but it was a lot of what was going on at work. Now, the difference between Deuce.com then and Deuce.com now is when she started Deuce.com, no one knew that the author of Deuce.com was Heather Armstrong. She wrote it anonymously. And like I said, she wrote a lot about what was going on at her workplace. And a lot of it was not flattering to the folks she worked with. So she had blog posts about, she wrote about, for example, the annoying Asian database administrator that she worked with. That's her words, not mine. She wrote about the loud and disgusting bathroom habits of the coworker in the stall next to her. She wrote about how she would ditch work at 2 o'clock in the afternoon and go home and lay on her couch and smoke pot all afternoon long. Deuce.com started to gain some traction in Los Angeles. It started to get some popularity. People started to talk about it. People started to share it. And her coworkers ultimately figured out from reading the stories that the author of Deuce.com was their coworker, Heather Armstrong, and some of the coworkers she was writing about were not really happy with the way they were being portrayed online. And this is the blog post that Heather wrote on February 26, 2002, titled Collecting Unemployment, in which she tells the story about how she was fired for writing Deuce.com. She wrote, "I lost my job today. My direct boss and the human resources representative pulled me into one of 3 relatively tiny conference rooms and informed me that the company no longer had any use for me. Essentially, they explained they didn't like what I had expressed on my website. I got fired because of Deuce.com." Then she continued in the last paragraph to tell more of the story. "2 weeks ago, an anonymous person emailed every vice president of my company to inform them I had written unsavory things on my personal website. I have yet to determine who sent the email or why this anonymous someone would hide behind a false email address. Conversely, I have devised several ways to torture said anonymous person when his/her identity surfaces." She continued to ask 3 questions. And we need to remember, right, this is not 2018, this is 2002. There's no Facebook, there's no Twitter, there's no Instagram, there's no Snapchat. Blogs were barely a thing. And so we need to kind of put ourselves, if we can, back in the mindset of the earliest parts of the 21st century and really think about how prescient, how much insight Heather had when she asked these three questions. And these are the three questions that we'll be discussing throughout the rest of the next hour. Number one, should I lose my job over what I have written on my personal website, especially if I've made sure not to mention specific places, persons, or events by name? Number two, at what point does my personal website, regardless of what I've published on the site, affect my professional life? And number three, what recourse do I have? She continued with some advice for her readers. My advice to you is be ye not so stupid. Never write about work on the internet unless your boss knows and sanctions the fact that you are writing about work on the internet. I would suggest to you that if employees did not do stupid things in general, but more pertinent to this morning online, I would need to find a different practice area. There would be no need for employment lawyers, and we certainly wouldn't be talking about social media this morning. Deuced.com or Deuced has entered the popular lexicon. In the Urban Dictionary defines deuced as to lose a job because of one's website. As in, dude, I heard Jenny got deuced last week. When we talk about social media, this is kind of what we're talking about. I think we all know kind of what social media is, but it is a vast array of websites online through which we don't just read content, but which we share content. So I think of the big three as kind of Facebook, Twitter, LinkedIn, there's Instagram, there's Snapchat, there's Wikipedia, there's YouTube, there is any variety of websites on which you go on not just to consume content, but to share or publish content, falls within this prism of social media. And 3-4 years ago, the multinational law firm Proskauer Rose ran their third survey of their clients, asking questions about their clients' experiences with social media. This is, every time I do this presentation, I go check, and this is the latest data we have from this survey is back in 2013, 2014. But the question asked was, is misuse of social media an issue with which your business has ever dealt? And if we look down here, bottom right, 2011, you see it's 43% of their clients reported that social media was an issue with which their business, misuse of social media is an issue with which their business has dealt. 2012, it's about the same. We're getting a little closer to the 50% mark. And their latest survey, again, we're now going back 4 or 5 years. We just see it just crest past the 6 o'clock mark to 52.33%. Let me suggest that if this survey was done again today in 2018, approaching 2019, I have no doubt that that orange line, the orange block, would be well past 9 o'clock, would be well past 75%, and probably closer to 100% than 75% of businesses for which misuse of social media is an issue with which they've dealt with their employees. And there's lots of examples of employees doing really, really, really dumb things online. This is a nurse. We know she's a nurse because A, she's wearing scrubs, and B, if you look at the post, the hashtag nurse, but she says apparently she was having not a great day at work. FU, hashtag nurse, hashtag tired, hashtag healthcare, hashtag hate my boss, hashtag so sick of work, hashtag need a break. Luckily for her, one of her coworkers saw this, shared it with her boss, and her boss gave her the break that she so desperately desired and fired her from her job. Again, the hashtags here really tell the story. Hashtag called in sick, hashtag my leg really hurt though, hashtag blocked my manager, hashtag I hope my coworkers don't rat me out, hashtag Sundays off. For this employee, coworkers did rat him out, and not just Sundays off, but every day off, because this employee also fired once his boss was shown a copy of this Instagram photo. I put risks, as I mentioned earlier, into two broad categories of risk that companies face with employees being online. It's a brand management risk, and then more of a risk management risk or legal management risks. I want to talk for a second about brand management because there's lots of things that employees can do online that can damage your brand as a business. There's a wonderful social media guru by the name of Jason Seiden, and I wish I could take credit for coining the term professional, but I didn't. It's his, but I love it, so I borrow it. There is no longer online separate personas for a kind of personal persona or a private persona and a business or professional persona. Everything we do kind of goes into the social media blender, right, and comes out as one blended professional image or professional profile, right? Business in the front, party in the rear. It's all one hairstyle at the end of the day. And so, you know, I'm very active online, as was mentioned at the beginning. I write a very active blog. I write 5 days a week. I use Facebook, I use Twitter, I use LinkedIn, I use Instagram, all for not just my personal life, but it's all kind of has a business, kind of marketing myself from a business perspective. But I'm very careful with what I post because I know that everything I post can be seen by clients, prospective clients, coworkers, my partners, whomever, and I don't want anything I write to reflect negatively on me as a professional, even though my Facebook page is personal. It's not a business page, it's my personal, like Jon Hyman on Facebook, but I also don't want prospective clients to ever to lose a client because of something that I've done online. So I guarantee you, if you ask your employees, if you go back to your businesses and ask your employees if they understand this idea of professionalism or understand that you could potentially hold them accountable for things they write or say online, even if it's their personal social media, I guarantee you they do not understand that concept. The majority of them will tell you, if I write something online, it's personal, it's private, it has no business interfering with my employment or my job. But the reality is that if it can reflect negatively on them, and it can come back to you as a business owner or a business, it can reflect negatively on you as well. Which is why I tell clients, number one, what your employees say or do online can harm your brand, and if it can harm your brand, it's absolutely fair game for their employment. But number two, your employees don't understand that. So they need to be trained. They need to be told. They need to be explained to them kind of what this means, right? So that they understand that they can be accountable. Some employees who did lose their jobs as a result of damage to their businesses' brands. Erica Escalante was interning for a business in Texas. She was driving somewhere with a friend of hers, drove by a cotton field, got out of her car, snapped 3 photos of her and her friend at a cotton field, and posted this to Twitter. We can all imagine what's under the red box, or the black box after the letter N. Posted this tweet, and within minutes, her company that she was interning for started getting bombarded with messages from people on Twitter saying, I can't believe that you employ these kind of racists. What kind of business are you that this is who you employ? She lost her job. Immediately, the company had to go into damage control mode and explain that this is not who they are and she no longer works for them. Erica Escalante took this tweet down. It's no longer there, except I have it. Anybody can have it because this story went viral. And if you do a Google search for Erica Escalante, you will find hundreds of copies of this image through various news sources and sites that published this story after the tweet went viral. So whether or not this is who Erica Escalante is, it's who people are going to think she is for eternity because this image is forever there, saved on Google, as a result of either who she is or a very, very poor decision that she made one day a couple of years ago. This is just from this week, a couple of employees for various businesses who lost their jobs because they thought it was funny to, on the left, you have, the left you have a couple who went as Jay-Z and Beyonce for Halloween, except they're not African American, they're white, and they're wearing blackface. On the right, you have someone who thought it was hilarious to dress up as in blackface as a mammy at work. And that photo was actually this employee who jumped up on a conveyor belt and started kind of shucking and jiving at work dressed like that. Both these people lost their jobs as a result. Here you have an employee who was so excited that she got her NASA internship that she decided to post, everyone shut the fuck up, I got accepted for a NASA internship. And then, this is on Twitter, Homer Hickman, who you see below, is on the National Space Council that oversees NASA, reminds her, language, maybe you shouldn't be talking about your new internship with language like that. And then Naomi, remember PG-13, right? Naomi then tells Homer Hickman, not knowing who he is, suck my dick and balls, I'm working at NASA. To which Homer then says, and I'm on the National Space Council that oversees NASA. And she lost her internship as a result, again, because she had no concept, right? This is not, I remind my dad all the time. I knew Facebook was done when I saw my parents were on Facebook, but that's a whole different story. I remind my dad all the time that when you're on Facebook and you post a comment on somebody's post, that you're not having a private conversation with that person. And so when my folks live in Philadelphia, but when the local newswoman, when she posts something on Facebook and you post a comment, I wish I was making this up, but I swear to God I'm not. When you post a comment on her post that says, your breasts look really nice today, Dad, everybody in the world can see that. You shouldn't be saying that to begin with, right? Because it's horribly creepy. But two, we can all see that. So now everybody thinks you're the creep that maybe you really are. But that's a whole, and if you ever meet my dad, we never had this conversation. Okay. Your employees will tell you if you ask them. If you ask your employees, they will tell you, I promise you, that I can't get fired for this. I can't get fired for this. I can't get fired for this because I have free speech, right? First Amendment, I have free speech. We have freedom of speech in this country, which yes, we do, except we don't, because the First Amendment of the Constitution doesn't apply to private employers. It only applies to government employers, public sector employers. Any public sector employers in the room? Right? Any government agencies? Right? We're all private sector employers, so your employees have zero free speech rights at work. And if your employee is dumb enough to tell someone on the National Space Council to suck her dick and balls, guess what? You can fire that person because free speech, period, does not exist in the private sector. And a lot of employees found this out in very stark ways. Just in the last year, I don't need to tell you how kind of ramped up our political discourse is in this country. This photo was taken, the tiki torches kind of give it away, but was taken at the Charlottesville March last year. And around that time, someone started a Twitter account called Yes, You're Racist. And the sole purpose of that Twitter account was taking photographs of the people who were at the rally, going online, figuring out who those people were, and letting those persons' employers know, you're employing a racist, what kind of business are you? And lots of people, including Peter, I can't pronounce his last name, lost their jobs as a result of Yes, You're Racist, outing them at Charlottesville and other marches and rallies. This employee also lost her job, and you think, all right, so it's a photograph of somebody giving the finger, big deal, except she was giving the finger to President Trump's motorcade. She was biking in the Beltway somewhere. Trump's motorcade went by, and I've always wondered, why, don't they close roads when the motorcade goes by? How could that person get that close to Trump? But whatever. That was his motorcade. She obviously has some strong feelings about the president, gave him the finger. She worked for a government contractor. This post went viral. After she posted it, she made it the cover, her cover on her Facebook page. It gained some traction, started to get shared, got back to her company. Her company, which was a federal contractor, had defense contracts, didn't like the fact that a picture of one of its employees giving the finger to the president of the country, who arguably could control kind of who gets the contracts that this company does business with. They didn't like the fact that this image was out there, and so they fired her. They fired her as a result. And again, private sector, no free speech rights, fair game to fire her. Another employee. This is actually the owner of a company who fired an employee after the employee objected to, an African American employee objected to this individual, obviously very right-wing, very pro-Trump, and apparently very racist with the stars and bars flag, and what have you, and not political, but one of my favorite examples of all time of an employee who just did something really stupid online to get themselves fired. We know he works at Taco Bell because it's hard to see, but there's the logo on his shirt there. On the left is a photo from his Instagram of him licking a stack of taco shells. Yeah, right. So if you eat at Taco Bell before, don't please. But if you Google like employees fired for social media, you'll find hundreds of examples of stuff at fast food restaurants. You'll find employees who like bathe in a sink full of lettuce that they're washing, that the photos have gone viral. Or this guy who decides to lick a stack of taco shells on the left, and on the right from his Snapchat, just got the call, I'm fired. Lots of risks to your brands, right? We can all laugh about this, but anybody going to Taco Bell right from here to eat lunch today? Right? No. So lots of risks to your brands from employees going online. I want to spend the rest of our time talking about some of the legal risks that exist from employees being online. And so they fall into three broad categories. There's discrimination risks, there's risks related to confidentiality, and there's risks related to what's called protected concerted activity under the Federal National Labor Relations Act. And you can say, John, we have all these, I understand we talk about the corporate risks, and I get that, the brand risks. We're going to learn some legal risks. Why don't we just ban employees from being on social media at all? And when clients ask me that question, the answer I give them is twofold. It's number one, you can't control what they do when they're not at work. They're only with you for 8 hours a day, give or take. So what are you going to do for the other 16? But even if you just want to control for the 8 hours a day that they're with you, and you want to say, don't go on Facebook, you're going to put filtering software on your server or on your computers so they can't go on Facebook or Twitter or what have you from their desktop at their desk. If an employee wants to go online, I promise you all they're going to do is pull this out of their pocket, right? I call it the iPhone-ification of the American workforce. Your employees have super powerful computers, in their pockets at all times. If your employees want to go online, they're going to go online. You can't control it and you can't stop it. So what I tell employers is, rather than try to prohibit something you can't hope to control anyway, just embrace it, right? We expect a lot of our employees these days. So if your employees want to go online and it's not interfering with their jobs, how they do their jobs, I say let them do it. If they're online so much that it becomes a performance issue, then you treat the performance issue, but don't try to put a technological ban or solution to what is ultimately a performance problem. If your employees want to go online, they're going to do it, right, regardless. So I say to companies, embrace it, right, and then when it gets to be a problem, just treat the problem. And in the meantime, train about these issues so your employees understand what their responsibilities are when they're online. Okay, legal risk number one, discrimination. And discrimination, the law prohibits discrimination on the basis of race, sex, age, disability, religion, national origin, what have you. And there's lots of ways that companies can get themselves in trouble via social media, lots of EEO discrimination risks with social media. The first one I want to talk about is what I call the Google background check. It's somebody comes in to apply for a job, you get their resume, you're going to meet with them for an interview, you want to find out what this person is all about. So you type their name into the search bar in Google, and then you get back a whole bunch of information. You can learn, have they posted pictures of themselves licking taco shells, or using the N-word, or how do they generally communicate, or do they appear to be a good cultural fit for your organization. Lots of stuff you want to learn about someone that can help guide your decision in whether to hire or not hire that individual. I'm going to tell a quick personal story to illustrate what can go wrong very quickly when you type someone's name into Google, and then how to handle that. So I have 2 kids. My son Donovan is 10, Nora's 12. Donovan, my younger, has a genetic condition called Noonan syndrome. Specifically, it's a mutation of the PTPN11 gene. He was diagnosed at 7 months old with this disorder. And in him, all right, and if you Google Noonan syndrome, you'll see there's a spectrum of like 300 different things that can be wrong with somebody. Some things are very mild, and some are life-threatening and very severe. In his case, he has a congenital heart defect that we monitor on an annual basis. He has celiac disease, so he can't eat gluten. He has a bleeding disorder, and he has ADHD. Or his main challenges with his particular syndrome. When he was 2 years old, he stopped eating completely, like shut down. We didn't know he had celiac disease. He didn't eat, and so what do you do when a little kid doesn't eat? You give him like animal crackers and graham crackers and cookies, and you try to get calories into him, all the stuff that was making him feel like crap because it was all full of gluten. We didn't know. Stopped eating. His gastroenterologist wanted to do an endoscopy to figure out why he was no longer eating, and so into the Cleveland Clinic, endoscopy, and then at one of the biopsy sites from the endoscopy, he developed a hematoma that was like the size of a baseball, because we didn't know at the time he had the bleeding disorder either. That was diagnosed at the same hospital stay, and he was inpatient, ended up being inpatient at the clinic when he was 2 years old for 3 weeks. February 2011, we're now in the hospital. My wife and I going back and forth every day with Donovan in the hospital, and now it's February 13th, the day before Valentine's Day, and I'm thinking like, all right, so this is like the worst possible, like least romantic place in the world, but I still want to do something nice for my wife for Valentine's Day, so what am I going to do? Right? Don't want to go down to the gift shop because I can guarantee she doesn't want like the commemorative Cleveland Clinic t-shirt to mark the anniversary of, right, our horrible 3 weeks staying at the Cleveland Clinic with our son. So at the time I had been blogging for like 3 or 4 years, so I decided what I was going to do was set up a blog for my wife. So she was a stay-at-home mom at the time, so she could write about our family, Donovan and his medical issues, and maybe use it as some outreach to talk to other families that are going through the same kind of stuff that we were going through with Donovan. And so for the next 4 years, she blogged pretty regularly. And then when Donovan went off to kindergarten, my wife went back to work. And if a company decided to put my wife's name into the Google search bar when she goes to interview for that company, they are going to learn all kinds of stuff that you would never want to learn about somebody before you're going to hire them, like genetic information and disability-related information, all kinds of things that you would never want to learn about somebody. You would never, in a job interview, you would never ask somebody, so tell me about your family and all their medical and genetic issues, but a company is nevertheless could learn all that stuff, right, from just searching for someone on Google. And while as trained HR folks, we all should know that we should not be taking genetic information or disability information into account when we're making a hiring decision. Nevertheless, if you have 2 candidates of relatively equal strength, and one has the son with the genetic issues and one doesn't, if I'm being honest with myself, and if we're all being honest with ourselves, right, who are we going to hire? we're probably going to hire the one that we don't have to worry about, at least immediately, taking time off from work to go to doctor's appointments and maybe hospital stays and run up our medical insurance costs and the like. Wrong, but honest, right? So what do we do so we don't come into possession of this information? A couple of things, a couple of recommendations. We still want to get the, right, has this person ever licked the stack of taco shells information, but we don't want to get the protected EEO information. So what I recommend that companies do is, if you want to get the good information and filter out the bad information, is have someone in your organization, but someone who is external to the hiring process, right, run the search, and then provide a sanitized, cleansed, filtered report to those people involved with the hiring. So that you will get the, uses the N-word, dresses up like Aunt Jemima, and licks taco shells, but you don't get the and has a son with genetic issues. Okay. LinkedIn recommendation, another potential EEO pitfall. LinkedIn is a wonderful business network, and one of the nice features of LinkedIn is that it lets you recommend people, right? Give recommendations for people on the platform. It's not difficult to envision a scenario where this can also go very, very wrong. Let's say, for example, supervisor has an employee and goes on LinkedIn and writes that employee a recommendation and says, Jane is the greatest employee I've ever had. She's like my left arm, and if she was no longer with the organization, I'd be lost without her. Greatest employee ever. Send, posted, what have you. A week later, let's say there's a reduction in force and Jane is included in the reduction in force, and let's also suppose that Jane is an African-American female in a wheelchair who's 65 years old. Guaranteed that that supervisor or manager's recommendation posted to LinkedIn a week before that employee was fired is going to be Exhibit A in that employee's race, sex, age, disability, discrimination lawsuit. Organizations should have, better have, protocols in place for how to manage performance appraisals for employees. And so your supervisors and managers need to understand that when they are evaluating employees' performance, they should stick to the formal protocols and avoid, for this reason, avoid posting these kind of informal performance reviews on social media. Also, risks that can arise with harassment. Harassment's been all over the news in the last year with the Me Too movement. Your employees are now not just talking for the 8 hours a day they are together at work, but they are talking 24/7 because they are connected online. And this online connectivity makes it much, much easier, right? Because of the relative, not anonymity, but protection of kind of hiding behind your keyboard or your phone screen to make comments, say things that you might not ever say to someone in person, but nevertheless would be equally offensive to somebody. And so, your employees need to understand that, their responsibilities to not harass, not bully, not offend their coworkers, not just extends to the 8 hours they're together at work, but also to if they are connected with each other online, all the time they spend, whether it's Facebook or Twitter or Instagram or what have you, potentially connected there as well. And the issues get multiplied when it's not just co-equals that are talking to each other, but subordinates that are connected to their superiors. Here you have an employee who didn't really like her job very much at all. She wrote, OMG, oh my God, I hate my job. My boss is a total pervy wanker, always making me do shit stuff just to piss me off. And as if she didn't get her point across the first time well enough, again in all caps, wanker. What she forgot was that she was Facebook friends with her boss, the pervy wanker. And he saw her post and then said, hi, I guess you forgot about adding me on here. Firstly, don't flatter yourself. Secondly, you've worked here 5 months and didn't work out that I'm gay. I know I don't prance around the office like a queen, but it's not exactly a secret. Thirdly, that, quote, shit stuff is called your, quote, job. You know what I pay you to do. But the fact that you seem able to fuck up even the simplest of tasks might contribute to how you feel about it. And then he went on to fire her. And I can give a whole separate talk about whether it's a good idea or a bad idea to fire someone via Facebook comment, text message, whatever. Spoiler alert, it's a horrible idea. But that said, your employees need to understand and be aware of when they are connected with coworkers or bosses online, what they say or do, again, is fair game for their employment. Family Medical Leave Act. Employees are constantly getting themselves in trouble for doing things they're not supposed to be doing when they're supposed to be out of work, convalescing from an injury or an illness. This was, I think, Exhibit 35 to an employer's motion for summary judgment to have this employee's FMLA case dismissed. The employer won its motion. Her case was dismissed by a federal judge in Detroit. She was a nurse at a hospital in Detroit. She suffered what she claimed was a debilitating leg injury that required her to be off work for 12 weeks. While she was supposed to be at home convalescing, she was on a Mexican holiday. Now, maybe top left, maybe laying in her bed having a beer. Maybe that's consistent with her leg injury. But I don't think catamaraning is, for example. And I don't know what this guy down here is doing. But regardless, she had certified for her FMLA leave that she was unable to work because of her leg injury. She was apparently well enough to go gallivanting around Mexico, and as a result, she was fired, and the court upheld her termination. Employers also need to be careful with what they, in some cases, with what they do with information they find online. This is a lawsuit this Adrian Duane filed against IXL Learning, which is some company in California. He claims that he went on Glassdoor.com, Glassdoor, a website that allows you to write reviews of your employers, and made all kinds of complaints about, or comments about the company's lack of handling discrimination properly. Talking about, if you're not white or Asian, you can't fit in at the company, that all these people get better treatment if they fit in with the company culture because they're white and he's not. The company saw this post, fired the employee as a result, and the employee then sued the company for retaliation, saying, look, I'm complaining about what's going on at work, right? I'm saying that the company treats white people better than non-white people, or whites and Asians better than non-whites and Asians. I'm not white or Asian. I felt like I was being treated poorly as a result, and raises and benefits and other things related to the job, and I raised this complaint, and you fired me as a result. Companies need to be very careful with what they do, with information they find, they discover online, when somebody might be raising a complaint about what's going on at work, and put a thumbtack in that, because we're going to come back to this topic again in a few minutes when we talk about protected concerted activity and the National Labor Relations Act. Moving on to the second legal risk, second category of legal risk. Broadly, I have it lumped under the category of confidentiality, which raises a bunch of interesting legal issues. One deals with agreements not to solicit, non-competition-like agreements. You have an employee sign a contract that says, when I leave the company, I won't solicit customers of the company, business prospects, what have you, of the company for a period of years after I leave the organization. And there's been a number of lawsuits in which employers have claimed that employees that were connected on LinkedIn or Facebook or Twitter with customers, right? These are primarily salespeople connected on social platforms with customers of the organization. When they leave the company, they then either blast an update out that says, I'm now working for this company, or just merely in like LinkedIn, change the name of their employer, which then gets pushed out to their network on the platform. And the former employer said, by telling on these various social platforms, by telling our clients, our customers, that you no longer work for us, but you now work for a new organization, you breached your non-solicitation agreement, and therefore you should, you're liable to us for breaching the contract. You breached your contract. Universally, courts have rejected that argument. Courts have said time and again, there's been, 6, 8 cases looking at agreements like this in this specific context. Courts have said solicitation presupposes a specific intent. You need to intend to do something. You have to take a deliberate act to solicit somebody. And just because you are connected with people online and you blast out an update, you are not actively soliciting those folks. It's too passive to qualify as a solicitation, and therefore the courts have universally found that solicitations have not, these non-solicit agreements have not been breached in these contexts. So just the kind of takeaway from this point is that if you are concerned, right, if you are concerned about employees, right, I mean, we used to have Rolodexes on our desk before my time. Rolodexes on our desks with lists of contacts. We don't have them anymore. We have, LinkedIn, where we have all of our contacts, and that's portable, right? Employers don't control that, right? And so we need to keep in mind that the identity of who we do business with nowadays is very, very hard because of social media to control, as is illustrated by this point, by this case here as well. Phone Dog versus Noah Kravitz. Noah Kravitz, or Phone Dog, they're a website that reviews cell phones. Noah Kravitz was their director of social media. He maintained their Twitter page. When he worked for Phone Dog, he was at Phone Dog Noah. And he started the account for Phone Dog, amassed 17,000 followers in the course of a year or so, and then decided to leave Phone Dog. And when he left Phone Dog, he changed the account from at Phone Dog Noah to at Noah Kravitz, changed the password to something that no one at Phone Dog knew, and then got sued. Phone Dog said, "You worked for us, it was our account. You had no right to take it with you when you left." They also argued that the identity of its 17,000 followers were a trade secret. Twitter followers are public, so there's nothing secret about that. So that claim went nowhere. But this case went on for years, 2.5 years of litigation, and hundreds of thousands of dollars over who owned the Twitter account, Phone Dog or Noah Kravitz. And the problem that the court faced was there was no contract between the parties detailing who owned the account. The court looked at things like Twitter's terms of service to see how Twitter defined who owned the account. Anyone know how Twitter defines who owns a Twitter account? Twitter owns the account, right? Not the user, but Twitter owns your Twitter account. If you're on Twitter, and I bet if you looked at Facebook's terms of service or any of the other social sites, it's going to say the same thing. They own it, not you. Ultimately, this case resolved, and Noah Kravitz kept the account. But the point is, if you have employees that are using your social channels, your brands online for business purposes, all it takes is a simple contract that says this account belongs to us, the employer, not you, the employee, and when you leave, you agree that you won't take it with us and you'll give us the password and what have you. That's all it takes, right? And then you still might get involved in litigation if someone leaves and does something goofy like change a password and lock you out, but at least you won't have the court having to read like website terms of services that aren't very helpful, and you won't be involved in years of litigation to figure out who owns an account if you have a simple contract that defines who it is. I want to talk for a second about phishing as it relates to cybersecurity, because this plays in the social sphere as well. This is what everyone know what phishing is when we're talking about emails, right? Emails that are designed to get you to click on a link so that it will take you to a cyber criminal looking to do bad things to you, either access your account, steal your information, or install malware or ransomware on the device from which you're clicking the link. This is what a generic phishing email looks like. Again, very generic, kind of dear client. But again, the goal here is to get you to click on this link, which does not go to Amazon, but it goes to this website that will certainly do something other than take you to your Amazon sign-on page. We, as informed users of email and the internet, have gotten decent at recognizing emails like this as phishing. And so what the cyber criminals have done, and I promise you, they send phishing emails because they work. If they didn't work, they would find a different way to access your information and get you to click links. But these work, that's why they do them. And so understanding that we've gotten better at recognizing these, they've turned to social engineering to design craftier phishing emails. And so what do I mean by social engineering? I mean they are mining our publicly available information on social platforms to design much more targeted emails, specifically targeted to us based on our publicly available information to get us to click that link. What do I mean? Here is a socially engineered phishing email. This is a cyber criminal who is not sending the generic email, but is rather sending an email knowing that we are a member of the LinkedIn or Microsoft security group on LinkedIn. And so sending a more targeted email saying Bill Gates, right? This looks like a LinkedIn connection request saying Bill Gates wants to be our friend on LinkedIn. And if you're in the Microsoft security group, who in their right mind is not going to click that link and want to be connected to Bill Gates? Except when you do, it's not going to go to LinkedIn, but it's going to go to some phishing site that is going to install all kind of cyber oogly booglies that you're not going to want on your computer. I'm happy to send this to anybody that wants it, but this is a great summary of kind of what a phishing email looks like and how to recognize it. But things like misspellings in two lines, or weird subjects, or the subject doesn't match the content, or you have an attachment that you don't expect. All kinds of things you can do to recognize a phishing email, whether it's a generic or a more targeted, socially engineered email. Okay, last topic, protect the concerted activity under the National Labor Relations Act. The National Labor Relations Board, which is the federal agency that governs union management relations and collectively bargained workplaces, has gotten very active in the last 7 or 8 years around the topic of social media, specifically as it relates to what the National Labor Relations Act calls protected concerted activity, which applies to all employers, whether or not you have a labor union, which boiled down to its kind of basest of nuts and bolts means that employees have the right, whether they're in a union or not, under federal labor law, to talk about wages, hours, terms and conditions of employment between and among themselves. And if you retaliate against an employee because that employee has talked about wages, hours, terms and conditions of employment with other employees, you have an issue under the National Labor Relations Act. You violated that employee's right to engage in protected concerted activity under the Act, and employees, and the National Labor Relations Board has gotten very active in litigating cases against employers who fire employees for things they post online about what's going on at work. I want to give you a couple of examples, and I'm going to read this so I get it right. So, an employee by the name of Hernan Perez worked for a catering company in New York called Pier 60. Pier 60 was in the midst of a union organizing campaign. They were not unionized, but the union was trying to organize. There was an election coming up. Hernan had an issue with his supervisor, a guy by the name of Bob McSweeney. Bob liked to criticize Hernan. Hernan was very pro-union. Bob liked to criticize him a lot, ride him about how he was doing his job. Eventually, Hernan cracked, right? And he cracked by the day before the union election. He went on his personal Facebook page while on a break at work and wrote the following. Quote, "Bob is such a nasty motherfucker." That's about his supervisor, Bob McSweeney. "Bob is such a nasty motherfucker. Don't know how to talk to people. Fuck his mother and his entire fucking family. What a loser. Vote yes for the union." Okay. Bob McSweeney, the supervisor, someone shows that to him, one of the other coworkers that was not a fan of Hernan Perez, but was Facebook friends with him, sees that post, prints it out, gives it to Bob. Bob gets pissed that Perez wrote all that stuff about him and his family and fires him. Perez runs to the National Labor Relations Board, files a charge an unfair labor practice charge with the NLRB, and both the NLRB and the Second Circuit Court of Appeals, Federal Court of Appeals in New York, both said that the company unlawfully fired Perez because his criticisms of his supervisor were done in the confines of this union organizing campaign. The election was the next day. He wrote, "Vote yes for the union," pro-union message. So even though what he wrote about McSweeney and his family was horrible and deplorable, and no employer should be expected to condone that type of speech or misbehavior, because Perez was an ardent union supporter and couched his negative message with the "vote yes for the union," the employer was not within its rights to fire the employee. It was an unlawful termination. One more quick example to show kind of the extremes or the ludicrousness of the results when the board takes a look at what goes on online. Hooters Restaurant in California is having a wet t-shirt contest for its employees. It's going to have all of the female employees that work for this Hooters put on t-shirts, hose them down, and then it's going to decide which of its female employees wears the wet t-shirt the best. The judge for the contest is the restaurant's marketing manager, a guy who is dating one of the waitresses. Guess which waitress won the contest? Right, the marketing manager's girlfriend wins the wet t-shirt contest and the $300 cash prize that goes along with this wet t-shirt contest. One of the employees who lost thought the contest was fixed, went on her personal Facebook page and went on an expletive-laden rant about the employee, her coworker, the marketing manager, the contest being fixed, and her losing out on this opportunity to win the $300 cash prize for the best wet t-shirt. Marketing manager sees the Facebook post, fires her as a result. She goes to the National Labor Relations Board. She files a charge saying, "I was engaged in protected concerted activity. I was complaining about terms and conditions of employment." And the National Labor Relations Board agreed because the contest was compulsory. The employees had to participate, and there was a cash prize that went along with it. So therefore, the cash prize was wages. She was complaining about wages, and therefore her post about losing the contest and losing out on the $300 prize was a complaint about wages, protected concerted activity. She won her case as well. Which brings us back to where we started, which is Heather Armstrong and her advice for employees, right? Be ye not so stupid, as we've seen lots of employees do lots and lots of stupid things online. The bottom line, right, for employers and employees, or for employees and employers that are training employees, right? I could write a social media policy in 4 words, right? Think before you click, right? That's really what it all comes down to at the end of the day. Your employees do not understand, as I said before, their accountability for what they say or do online. And if they would just stop and think, right? Is this something that I want my boss seeing, that I want to go viral, that I want it to be right on the front page of the newspaper or on the 6 o'clock news, right? If they would just stop and think before they click, all of these problems would go away. But again, I promise you, they do not, which is ultimately why so many people have lost their jobs as a result of things they have said and done online. I thank you all for your time this morning. Do we have time for questions? If people have questions? Questions? Question?
Yes, the concerted activity and the language online, that doesn't include an employee who goes online and uses discriminatory conversation, does it?
Believe it or not, it might. There's a case not online. It involved a picket line at a Cooper Tire facility. Employees were on strike, and the company brought in a whole bunch of replacement workers to replace the employees that were striking, and a large portion of the replacement workers that were crossing the picket line were African American, and a large portion of the striking employees were white. And when the African American employees were crossing the picket line, the white employees, the white striking employees, were yelling the N-bomb at them. Someone got a watermelon thrown at them. I mean, horrible, horrible, horrible racist stuff. The African-American employees went to work, complained. The company fired the striking workers, saying, we don't tolerate racist behavior at our workplace. You're out of here. The white striking workers went to the NLRB and filed a national unfair labor practice charge saying, we were engaged in protected concerted activity. They were crossing the picket line, there was a strike, and we have the right to try to dissuade them. It's our right to try and dissuade them from entering the workplace. And the National Labor Relations Board agreed with the striking workers. Right, and you're shaking your head, it's horrible, right? Right? And what's an employer's, what kind of choice does an employer have? Because you're either, if you do nothing, A, you're awful, but B, you're also violating the employee's rights to be free from racial harassment at work. And if you do something, you're violating the striking workers' rights, according to the board, to to throw watermelons at people as they cross your picket line. So yeah, it's a tough position for an employer to be in. But to answer your specific question, there is case law out there that suggests that in the right circumstances, like racist or other kind of EEO-related conduct, might not be enough to take it outside of what's protected. Any other questions? All right. I'm going to stick around afterwards if people have more. I am not difficult to find. You can just Google Jon Hyman, Cleveland employment lawyer. But as mentioned before, I do write the Ohio Employer Law blog 5 days a week, Monday through Friday, at ohioemployerlawblog.com, where I write about this stuff all the time. I'm on Twitter. I'm on LinkedIn. Again, I don't hide online. I do curate what I write for all the reasons we talked about, but I don't hide, and so easy to find if people want to find me online. So thank you all for listening to me this morning. I appreciate it.